Okay, we are.
Okay. All right. On November 30th, one of my best friends in South Florida passed unexpectedly. And he was an advisory board member for ICAVA. His name was Larry Thelmus. Larry Thelmus had just spent the Thanksgiving weekend with his family down in Key West. And he and I were actually planning to travel at some point after the first of the year to the island of St. Thomas in the Virgin Islands. There was a restaurant there that he was being offered that he was considering buying. And he had a company here called Florida Clear Energy. And they were, and they are, if you will, electrical supply providers, bulbs and fixtures and so on and so forth. And he had just landed a 7-figure contract that was good over 3 years with the Broward County Convention Center project. Family was doing well, life was good. I get a call on November 30th, and I'm on a Zoom, and I see Larry's calling me. I click, to send a message that I'm on a meeting, and I call you back. I call back, his wife answers the phone, and so that was the first strange thing. And then the next thing I know, she's telling me that Larry has passed. Mm-hmm. And I mean, me even talking about it right now, I can still feel that ton of bricks falling on top of my head. And then I find out the next day from a text from a friend that there was a GoFundMe solicitation on his Facebook page. Mm. Like, oh my God, what the heck, And I know, there's some implication here. So I called to find out first to make sure that it was legit, and it was. And then the second thing I found out is that Larry died without a will. Third thing I found out was he died without life insurance. Mm. Okay? And so I've always understood the estate planning was important, particularly after my wife, who died November 2nd, 2007. And she died without either one of us having, created a will. And fortunately, there was life insurance. And on top of that, she was a wealth manager for a bank. Mm-hmm. So what I'm saying to everybody here is that the education, the consciousness, the sophistication, the intentions, any and all of that does not mean a thing if you don't follow through and do what you need to do as it relates to estate planning. And the pain that that family is going through missing Larry has been exacerbated by the pain of him dying without a will and without life insurance. Larry was a proud guy, and me and a couple of other friends, and we're continuing to work with the family to help them to secure and stabilize the business. And I think that we're actually going to work things out. We had a great meeting yesterday, and we're following up with that this evening. That's the reason why I'm having to jump off. So, but again, the pain of losing him should not be exacerbated by the fact that he didn't have the life insurance and he didn't have the will. The pain of losing a spouse or a loved one should be lessened by the fact that you have planned and that at least their financial affairs are going to be in order. So guys, I implore you, don't think that, there's always tomorrow, because tomorrow is not promised. Mm-hmm. Don't think that you're going to get around to it and you're planning for it if you haven't done it. That's what we call good intentions, bad execution. So I'm not trying to be Debbie Downer or, anything like that. And, I'm just saying to you guys, what's being talked about here today is critically important. And not only listen to what they're saying for your own family, but share this. Matter of fact, Larry's wife has a financial planner who's a member of ICAVA, who's also on our ICAVA advisory board. So sitting along with Larry, we're all friends. And she is retiring in June, has everything all set up. Matter of fact, she told us yesterday that she saw some notes in Larry's calendar that said, finalize your life insurance. He never got around to doing it, okay? And this friend of mine, who was, again, friend of Larry's, he's beating himself up because he did not, really push Larry about getting his life insurance because he didn't want to be an overbearing friend. Guys, be overbearing, okay? Because you are doing something that is for the good of them and their family and their loved ones. And those loved ones may be you. So that's all I wanted to say. And I want to say, Keith and Shannon, you guys are doing a phenomenal job with a very valuable service that you're providing. And I just pray to God that more and more people, and we're going to do everything that we can to get the word out, you know, because we as a people, you know, have probably less, if you will, to leave. So it's even that much more critical that we have life insurance. And God, man, you can get $100,000 of life insurance so cheap these days. It's not even funny. So it's really criminal when we don't do that. So again, let this be, if you will, all that I'm trying to do, a lesson as to what can happen. It's possible. Don't think that you can be the one that doesn't do this, because it can happen to you if you don't act and do the things from a estate planning standpoint that you need to do. Take advantage of this. Talk to your friends, your brothers, your sisters, your moms, and everything. Make sure they've got their affairs in order. You're not bugging them. You are saving them. You are saving your family. Okay? So, all right, that's it. I'm sorry. Didn't mean to get on the soapbox, but this is a very emotional time for me as it relates to this issue. And I just really need to be able to share that and hopefully share or to spare someone the grief that I know this family is going through right now.
Yeah, thank you so much, Hutch. I think that was absolutely timely. And you're right. The grieving process is difficult enough without having to worry about the business aspect of death. And so this is exactly why we use platforms like ICABA. And thank you for providing such fantastic platform for this to educate people, because we all know that we do better when we know better. And the only way that we can know better is the educational aspect of it. And so I appreciate your being candid with us and open. I know those wounds are still open, but you are absolutely right. There is no time like the present to have that family meeting, to have that discussion, and sparing somebody the grief added to the grief on top of the grief is all that we aim to do.
You lose somebody and you're trying to figure out how you're going to bury them. Oh my God. You talk about adding pain and pouring more pain on top of pain. It's just crazy. Right. You just said something, and you say it all the time, Shannon. I love it. You know, we know better, we do better. And I'm going to leave you on this. I'm not going to say any more. But knowing is not enough, we must do. Willing is not enough. No, knowing is not enough, we must apply. Willing is not enough, we must do. So that's on top of what you said. I mean, you know better, we can do better, but we got to do it. You know, we can't just talk about it. We got to do it.
Right. Right.
Thank you, guys. So again, I apologize for interrupting the flow.
You didn't interrupt. You started us off the way we needed to be started, with the right frame of mind. So
that's right.
Okay. Well, I got to call Terry's wife, and we got to talk about some of the things that we talked about with the lawyer today. And blessings to everybody, and look forward to talking to you soon.
All right.
Thanks, Hutch.
All right. Take care.
All right. Started.
So I think we have, is everybody on the call familiar with ICABA? No, I don't think so. Okay.
No. Yeah, they may not be.
Okay, so ICABA stands for International Career and Business Alliance. It is a worldwide organization comprised mostly of people of color who are interested in collaborating through networking and making better futures for ourselves, both personally and professionally. Jerome Hutchinson is the brainchild of ICABA. He came up with the idea. He executes it fantastically and has a wonderful team of people surrounding him, helping with all of those fantastic efforts. So I can't speak highly enough of ICABA. I'm a charter member of the Atlanta chapter, and it has been a phenomenal resource. Not only the webinars that we do, this being only one of many, but there's also a fantastic platform online, ICABA World Community, where you can go and you can research and find out information about various aspects, professionally and personally. Keith and I do these workshops under the estate planning section of ICABA World. And it's always our pleasure and honor to come before you to give you information, just like Hutch was saying, give you the information, provide you the education so that we can go forth and know better and then do better. So he's absolutely correct. The execution of it is all that it's worth, because if you know it and you don't execute it, then it really means nothing. And if you know it and you don't share the information with others so that they can execute it, then our communities end up behind the power curve. And we're trying to create legacies rather than leave continual messes. So this is the second in our series of that family meeting. The first one was about pre-death planning and what happens at that family meeting. And I don't know, I closed my window, so I'm not sure how many of you all are on here, but
we have 6 right now.
Okay, so having that family meeting is critical. And I just want to start off by reiterating the fact that it's not just one meeting. It is a series of conversations that, if you look at this picture here, they have young people through seasoned people, and it can never be too early to start the conversation. You know, the conversation changes with time, changes with family dynamics, changes with understanding level. You know, an 8-year-old and an 80-year-old have completely different levels of understanding, but both of them need the information. And later on in this, I'm going to tell you a personal story about that 8-year-old that needs the information just like the 80-year-old. So without further ado, we're going to kick it off, because we try our best to end promptly at 8 o'clock so as not to take up too much of your valued time.
When we talk about what is the family meeting, Shannon mentioned that the first part of it is to share relevant information. We say family members, who that is will of course depend on who you think is relevant. And sometimes that's part of the question is, does family include spouses of children or other people that may be not blood, but part of, what we, as we know, many times we have people who are family, but not literal family. So, you define who that group is. Why? Because we want to try to prevent surprises. Part of it is that we don't communicate. And obviously we just heard a story of, unfortunately, a situation that did lead to a surprise. I'm sure the family figured out day to day, we're doing well, financially, everything is going well, we got this contract, but they didn't have the structure behind it if something went in a different direction. So we want to try to prevent those surprises. And of course, also, if there is a plan, we want to make sure people know that there's no disagreement or discord. They may not necessarily all see the things the same way, but at least if you talked about it, they can accept it, maybe, think about it, stew on it, but then just come, get out their feelings and come to an understanding that this is the way it's going to be. And of course, you get to explain to everyone at the same time. Sometimes we like to do things one by one, kind of massage the talk to each person, but that also creates distrust because you're not sure what the other person heard is exactly what you heard. And that may exactly be the reason why it was said one at a time. So when you have everyone getting the same exact information at the same exact time, that also prevents many times, hopefully later, some kind of contest or something where someone thinks, well, you did something or you're not following the wishes, but if everyone heard the same thing, you take that out of the equation.
Right. And the benefits about having that family meeting is the fact that, one, you can never say it enough. You have to have that discussion. You must have the discussions over and over again with people so that everyone knows. Everyone doesn't have to, like Keith just said, everyone doesn't have to be on the same page, but everyone should at least have a base level understanding of what's going on and what would be expected and inspected. you have to inspect what you expect. Mm-hmm. And the only way to do that is to have that discussion and make sure everyone is on the same page. And having that family meeting ahead of time lets you know when, Big Mama might be talking about something, but that's not what she said last week. And she doesn't seem to be herself today. All of those things come out. And so having it while somebody is of sound mind and able to make those decisions, and everyone knows they are of sound mind and able to make those decisions, it puts it out in the open, it's obvious, and it makes it a much better situation, so that in the possibility of somebody becoming incapacitated and the certainty of death, you know, I like to talk numbers, even though I really don't like math, but I know 100% of us are going to die, right? And most people don't think about it that way, but it is something that there's no way around. We just don't know when. And so having the everything planned out, you know, you hear people talking about, oh, I got to get my affairs in order. Absolutely, everyone should have their affairs in order, and nobody over the age of 18 is excluded from this. All right, and I forgot to mention, if you have any questions as we're going along, feel free to pop those in the chat window.
So we kind of would talk about how to organize this, and we said we're going to kind of start in a category. So the first category is intestacy. If you've heard that term, that means you do not have a will in place. So when you hear all these media reports that, you know, the celebrity didn't die without a will and such, that means that they were intestate. They did not have a last will and testament. Then the next thing is, as lawyers, many times we have a plan that is what we call will-based. So the will is the main vehicle for distributing property. And then the other option is trust-based. So if people here may have heard of many times, particularly of a revocable living trust, where something you establish while you're alive, that will often be marketed to avoid probate. So many times people kind of distinguish between having a will-based plan where you have to go to court versus a trust-based plan where you don't have to go to court. So the first two, intestacy and will-based, will definitely require you to go to court. That's what probate court is actually for, if you heard the term probate court. And then trust-based plan, you will still need a will. So we'll point that out. You will still need a will, but many of the assets may already be in the trust. So what actually passes through the court may not actually be that much if you have taken the steps while you're alive to fund it.
Right, and I think it's great that Hutch came on and well, it's great that he came on and said everything that he did. It's not great that the situation happened, but that is an excellent and timely example of intestacy. And so we're going to start with intestacy. You all just heard when Hutch was talking about somebody who passed away without a will. I'm going to bring it closer and talk about Chadwick Boseman, because we're all familiar with him, and he passed away, what, a month or two ago, 2 months ago maybe, and he did not have a last will and testament. And so various state laws indicate what happens when a person passes away intestate, but overarching, all states have a plan in place, state's plan for you to die without a will. So every state has a plan in place that says, if a person passes away intestate without a will, this is what that looks like. In Chadwick Boseman's scenario, he passed away without a will after having had gone through cancer for the last 4 years. And he was a newlywed, right? So some people say, well, you know, they just got married. Why should she get anything? The law says if they got married yesterday, she is still his spouse. She or he is still the spouse and would be, depending on the state, entitled to something. Most states have a plan in place for what that looks like for that spouse, and whether they get everything, whether it goes to spouse and children, whether it goes to spouse and parents, whether it goes up or down or out. And when I say up, that means it goes up to parents if we were to look at a family tree. If your parents are deceased, and it goes down to children. What if you don't have any children? It goes out to your siblings. And so most states, their laws of intestacy are structured the same way. It just depends on what it looks like for various states. So bottom line, passing away without any plan in place is the absolute worst thing that anyone can do. Okay, most people think they don't have anything, which was, I believe, Robert's question. What if people say, well, I don't really have anything? Well, everyone has something, and we all work too hard for what we have. My grandfather used to say, if I die with 3 pennies in my pocket, he had 3 granddaughters, each of you get a penny. Okay, and look, he meant that. Nobody is getting anything other than those 3 pennies. So everyone has something, and depending on the state, the assets that you have, even debt, can get carry forward with you into death. And so everyone has something that they can account for in life.
Shannon, I wanted to make sure everyone's clear. Intestacy is something that you start at that status. So when you are born, you are intestate. Okay, and at a certain age, depending on the state that you're in, it may be 18. In our state, like Georgia, you can do 14. Certain states will say this is when you can start making a will. So up until that point, you are intestate, and then you opt out in essence by doing a will to move from intestate to having a testamentary plan. And the other thing is, just so you understand also from the state's point of view, the reason why they have intestate plans is not only to have order, to have, it goes to people that are around, but to have a catch-all that if they can't find somebody, it's going to go to the state. So if that's why they have a plan, they're like, all right, if people don't claim this stuff, we'll wait a few years and then we'll claim it. So you definitely don't want to be intestate, because the state's plan is that if they can't find someone for your stuff, it'll make sure that the state of insert state will get it.
Mm-hmm. And they're happy to open a probate action on an intestate estate. Think about, we can name celebrities all evening. All right, Chadwick Boseman, we'll start there. Then I'll go backwards to Aretha Franklin. Before her 8-hour funeral was over, the state of Michigan already had that probate action open. Prince, no will, died intestate. Michael Jackson, originally they thought he died intestate. Later on, they did find a will. But at that point, they had already started probating his estate and named administrators. Martin Luther King Jr., no will, died intestate. So yeah, Keith is absolutely right. That's why it says on here, choices. We are all born intestate. And when we reach that age, that's when we have the choice to either cancel that out and have a plan, or continue in our lives as intestate citizens. All right, so I don't think we need to say much more about intestacy other than it can be too late. All right, it can absolutely be too late. It can not be too early as long as you've reached that age threshold. And like he said, it varies by state. Here in Georgia, it is 14. But as long as you've reached that threshold, it can be too late. If you are no longer of your correct mental faculties, you cannot then plan your estate. It's too late at that point. If something happens to you and you find yourself in a state where you can't make your own decisions, at that point, it is too late to plan your estate. And so it can never be too early, but it can absolutely be too late. And we should also think about our families when we talk about intestacy. We know our families, you know your families better than anyone. And every family has their cast of characters. Keith and I were talking earlier, and I said it's kind of like a play, a stage play. We laugh at everything that Tyler Perry does, but if you look at all of his plays, he is like spot on. Every family has all of those characters, right? And we all have roles in our family situations. There's generally somebody who's the responsible one, and there's someone who's good with money, and there's somebody who's caring, and like everyone has a role. And when grief sets in or somebody passes away, sometimes those roles change, just because maybe it's the matriarch or the patriarch of the family that's passed away, and now someone else has to step into that role. Or those roles change because the sibling squabble changes or whatever the case may be. But generally speaking, people maintain those roles. And just because somebody becomes incapacitated or somebody passes away doesn't mean that you should expect that person, for instance, who's the taker. Don't expect them to now no longer be the taker. They are set in that role. That's who they are. That's what they are. That's how they will be, even after death. So, or after someone else's death. So just be mindful of that when you make these choices. You know, if you choose to pass away intestate, recognize that if you are a family that has 10 children, 2 of whom are estranged, 1 who's living in the house with you, and the others are scattered, know that if you pass away intestate in most states, that means all 10 of them get a tenth of that pie, right? And you don't get to decide. And if Jimmy is the one who's always the taker, believe me, Jimmy is going to come forward for his part. And if Susie is the one who's estranged, Susie is going to come forward wanting her piece of the pie. So again, know your choices and know your family and have those discussions with them.
And that Sharon made a perfect point that, you know, there is no choice. That a lot of times we get but mama said I was supposed to have this, or I know daddy didn't want them to have that. All of that goes away in the testacy. It is a straight, whole statute. So if you want to have any options at all that involve your personal choice, that reflect your family situation, the only way to do that is to go and make a will or trust with, and I emphasize this, please, with some guidance from an attorney, hopefully, that you can write it down properly, because it has to have certain formalities to execute the actual document. And then you want the language of the document to do what you think that you want it to do. And many times that's also part of the problem is some of the simple wills aren't really going to satisfy your needs. So please understand the necessity for detail on many of these things.
Yeah. Yeah. And then also with that going back to the family scenario, especially if you are a blended family, or you have people that you consider family, but they're not really born of the family, adopted into the family, marriage doesn't count. Stepchildren in some states don't count. So if you want to account for those people who would not otherwise, what we say, take under, if you had a will in place, if they wouldn't otherwise take from the estate or be entitled to a portion of it, and you want to account for them, you must have a plan in place for that. All right, let's see here. So which documents do you discuss when you're having that family meeting? And again, it's not just one meeting. It can be one meeting every year. It can be one a week. It can be, you know, one here. It could be one at the family reunion. It could be one, you know, after whoever passed away, whatever it looks like for your family. It is not just one meeting. It should not be, because estate planning is not a one and done thing. You can alter things, you can adjust things, and you should, as age, space, time changes, faith, family, fun, fitness, as all those things change, those are excellent opportunities to revisit your estate plan. And in so doing, have that next meeting, have that next series of meetings, or whatever that looks like. But what should you discuss in that meeting? There are basic documents that facilitate the plan. All right, we've all heard somebody say, well, this is what I want. Okay, the attorney in me always says, make sure you have it in writing, and make sure you have it in writing in the proper document. Otherwise, it carries no weight. So, and it has no legal effect, no legal force. So what documents should be discussed? And some of these we will be talking about in upcoming webinars. But the first one, we have already had a webinar on that one. Feel free to go to ICABA World Community and review the video on that. But that was on Advanced Directive for Healthcare. And so we're going to go into some detail on what you talk about in that Advanced Directive and how that is generally speaking for while you're living, but there are some after death, post-death components that are involved in that document.
So the next one is what we usually hear about is when people say they have to get their affairs together, is the will. And the will is only going to take effect at death. So if you have a will written, you can always change it, subject, like Shannon said, to your mental capacity. But if you are in your right mind, you can always have the ability to update it up until the moment that you pass away. At that point, is now going to be in effect whatever you have in writing, but a will is only in effect at death. So that is one of those documents that you will use in the future, and it won't help you right now.
All right. The third document that we're going to talk about is a revocable living trust. And a revocable trust is an added estate planning tool that many people put into place in order to take their assets, whether they are monetary, real property, financial, whatever the asset is, take that asset out of their individual name and you move it into the trust. And then the trust now becomes the owner. The trust is an extension of you. It's like your left arm if you're right-handed, or your right arm if you're left-handed, right? But it is an extension of you, and it works in conjunction with a will. I will repeat that. It works in conjunction with a will. So having a trust in place and no will, not good, because then you still pass away intestate, right? And so anything that would not be in that trust or would not pass outside of probate now is still subject to the laws of intestacy. And so if you have a trust, you should also have a will in place that says I leave everything in the trust or otherwise directs it.
And then the beneficiary designations, these are forms for certain things that pass by contract, your life insurance, your 401k, your 403b, certain things that you are directed to go to someone else. So similarly to a will, they only kick in effect when you pass away. So like the revocable living trust, Shannon said, we just as living trust, you can set it up while you're alive. It will continue after death, but a will and beneficiary designations, they will not kick into effect until after you pass. A will goes through the probate court, but the beneficiary designations most of the time will not. So if you have life insurance and other things, they will pass outside of probate and go directly to someone, which makes them very beneficial.
Correct.
And we also have irrevocable trust. Irrevocable means once you set it up, you're not able to undo it, at least not easily. They have certain laws now that allow you to little bit of flexibility, but the key part of the irrevocable piece allows you to do certain things that the revocable does not allow you to do. It has to do some tax planning. Once you have an irrevocable status, if I'm considered as giving it away, now I can use some of what we call a state and gift tax exemption. And then if someone has any kind of government benefit where they are trying to qualify for a means-based, say SSI or Medicaid that have certain tests, if you have considered to have given it away, they cannot consider it as yours anymore, and you can potentially preserve those benefits. So there's a reason for distinguishing between the trusts that are revocable and the trusts that are irrevocable.
Right, and the tax planning is key on this because an irrevocable trust gets its own EIN number. It's a standalone entity, whereas a revocable trust is still connected to you. And so any of those assets that are in the revocable trust are still countable for government benefit purposes as well as for tax planning. Let's talk about an advance directive for healthcare and that HIPAA consent form. Essentially, these are part of your living estate plan. So this is for while you're still living. The advance directive for healthcare indicates what your medical wishes would be if you're unable to speak for yourself. But that document has within it a portion that transcends and follows with you into death for a period of time. And so there are certain things that you discuss in the advance directive or on the HIPAA form that have to be in place for the after death or afterlife period. The first part of that is whether you want to be buried or cremated. I have heard recently stories of somebody that said, well, so-and-so passed away and she always told me she wanted to be cremated, but now she told somebody else that she wants to be buried. And now the family is fighting over whether to bury this person or cremate somebody. It's kind of like Hutch was saying, sometimes somebody passes away and you have to deal with the grief of trying to figure out what to do, how to pay for it partially, and what would the decision have been. So this document allows you to set that up ahead of time so that the family can simply grieve. They know this person wanted to be buried. This is where they want to be buried. This is how they want to be paid for. Like, all of that is in the document. Or this person wants to be cremated. This is where they want those ashes spread, or this is who they want those ashes to go to, or they want to have the ashes now interred at a cemetery. Whatever the wishes would be, this is the portion of your estate plan through your advance directive where you are allowed to say, this is what my wishes would be. So that, again, your family, your loved ones, the people that you leave behind don't have any questions. And there's no surprises after the fact when they go back and look and say, oh, this says that they want to be buried.
And for Georgia, we want to make sure that you understand, we don't know, I know some people here aren't from Georgia. This document, the Advanced Directive for Healthcare in other states, it might be multiple forms. We have a living will and then a separate healthcare proxy and other things that decide. We have one consolidated form in our form in Georgia. You can say where you want your body to go. If someone agent has the ability to make a donation to a medical program or a medical school, or you donate your organs. Sometimes it's a question, well, if I have my organ, donation marked on my driver's license, does that conflict with that? So no, this form is just saying the agent has the ability to donate if you give them the ability to do that. Autopsy, obviously, sometimes some people say they don't want an autopsy, but sometimes we always say that you might want to leave that option open in case if there's some kind of medical malpractice question or some reason they might want to check your body. But autopsy in this document does not affect law enforcement. If they want to do an autopsy, they will not worry about whether you prohibited it in your advance directive. And then, of course, access to your medical records, that's a HIPAA piece. Of course, there's a lot of protection around sensitive information from medical records, but you, as part of your consent form, can tell the world that I give these people access to my medical records, and you can say for a certain period of time after death. So the question is not, okay, just while you're alive, can they still go to the doctor and still get old records? And usually I'll do at least 2 years or something, because you just never know what's gonna come up. But the key thing I want to make sure people understand, especially with the burial cremation that Shannon mentioned, that people will fight over that. I've seen places in books where they have people or this will software, and they'll have that designation of what you want with your body in a will. Do not put that in a will, because people, especially if they're grieving, they're not looking at that will until after they do whatever they do with your body. So if you said, I want to be cremated, and they don't look at your will until after they buried you, all of a sudden, oh, he wanted to be cremated. So you don't want to put that kind of information in the will. You want to have it in the advance directive where someone will see it before.
Yeah. Yeah. And I just want to bring this back around to the fact that we're talking about having those family conversations or that family discussion. So all of these things are things that we, as the people putting these in place for ourselves, should discuss with our family, with our loved ones, with our business partners, with whoever needs to know the information. Where do you house these documents? Wherever you're comfortable with housing them, and wherever somebody who would need them can get to them. Okay, I've heard stories of people putting them in the safe and locking the safe and nobody knows the combination. Well, then it's done no good, right? I've also gotten calls from somebody at the hospital. Oh, I left my documents at home. Can you email them to me? Well, I just happen to be one of those attorneys that will save a digital copy for people. But if that's not the case, then you need to plan accordingly. I had a family member who always said, if anything ever happens to me, look between the 2 towels on the top shelf. Okay, as a little girl, I heard her saying that from the time I was a little girl. Don't use the towels on the top shelf. Well, I couldn't reach them at that time. But later in life, after she passed away and we're going through things and we look, all of those important documents and diamonds were in between those towels in the top shelf. Well, she had inadvertently had that discussion over and over and over again about the stuff is on the top shelf of the linen closet. All right. Was it a formal family discussion, family meeting? No. But was the discussion had? Absolutely.
And just so we talk about that burial cremation issue where someone was fighting, that's probably why you want to have that family meeting, because if you pick someone who's on your as your agent and you say, I want to be, say buried, and then like, I'm not going to follow that. I think you should be cremated. That might be the opportunity for you to hear that and change your plan. So that's another part of the family meeting benefit, is you get to get some feedback of whether, people will follow what you intend to do. If you get a sense that they're not going to follow, they're going to challenge, that gives you a heads up on that maybe you need to, go in a different direction.
Right. Right. And it also adds the level of talking about it financially. A lot of times people say, I want to be buried. I want the best casket there is out there and blah, blah, blah. That you talk about people having wine bottle taste and beer bottle budget, right? That transcends into death. If you have planned in your head or in writing for a wine bottle or champagne bottle funeral, but all you leave for your family is a beer bottle budget or less, GoFundMe, then your wishes are not going to be followed through, especially one, if it's not in writing, and two, you haven't discussed it with the correct people that surround you. All right, so we talked about the Health Advanced Directive for Healthcare. Let's talk about that last will and testament. So the first thing that needs to be in a last will and testament, after your name and all of the pertinent information, is you name an executor. And that is the person who, upon your death, will take that document, the will, to the probate court and say, this person has passed away. May I go about the business of administering the estate? Right, you must be very careful and prudent about who you choose as that executor, because they are going to be responsible for dividing the assets and distributing the assets the way you have spelled them out in the will.
And the second piece here, this is absolutely critical to remember. We talked about doing a will-based plan or a trust-based plan. This item here with appointing guardians for minor children can only be done in a will. So you can have millions of dollars in that trust, but if you have minor children, you still need a will, even if everything was fully funded and you don't need to actually move any money, because a will is the only place that you can appoint guardians for your minor children. And that is absolutely critical, that everyone with minor children needs to have a will just for that purpose. And then, of course, that starts that discussion of not only who are you going to appoint, but like Shannon said, you got to talk about money, because if I say, I want you to be guardian of my children, then I might want to coordinate my estate plan to make sure you have extra funds, because regardless of how benevolent I am, if you give me 2 or 3 kids, I really would like if you gave me an extra $500,000, $1 million to help take care of them, because you're going to break me by giving me these children without giving me corresponding money. So that's a very important thing to think of, not only who's going to watch them, but making sure they have the ability to take care of those children.
Yeah, and Keith just brought up something that we were not going to talk about, but it just popped into my head when you just said that. This is also the time to talk about life insurance, especially if you have minor children in place, because especially if you have a child support obligation on you. Child support obligation does not die with you. So somebody, if you pass away leaving a minor child and you have a child support obligation on you, that family, that estate can come after you and everything in that estate, even things in the will, for that child support obligation. So not only should you, if you are the custodial parent, have a guardianship portion in your will, but if you're the non-custodial parent and you have a child support obligation, you should also take care of that. Beneficiary choices. who gets what. That's what goes in your will. You know, if you want your cousin Sarah to have the china, and you want so and so to have the sneaker collection, and you want so and so to have the piano and whatever, that's the document that you use to include that. If you have a purely will-based plan. If you have a trust-based plan, you can put most of these things in the trust. So making sure your choices are known goes in the will. Who gets what, and what all you have goes in there. Remember, a will is a public document. Anyone can see that upon it being filed with the probate court. And in most states, it is a requirement for it to be in writing. And also in most states, there is no requirement for there to be a reading of the will. That most of the time that is sensationalized for our television viewing pleasure. But in most states, there's not a requirement for there to be a reading of the will. So when that person comes forward and says, well, they didn't even read the will, well, maybe there wasn't a requirement for it. So know what all of those requirements are.
And with the beneficiary choices, I want to bring this up. Shannon mentioned this earlier. If you have those family members that aren't quite family, or if you have stepchildren that you want to treat like your children, this is in a will where you have to spell that out. So if you just say my children without any more, you might accidentally leave out your stepchildren that you intended to include. So you have to be very specific in that beneficiary choices, who gets what. You have to lay that out and make sure you might have to go into great detail to make sure it's clear that you are including people that would ordinarily not be included by the normal statute. And then also, we won't get into this here, but there's something called an elective share in certain states. We happen to be the only state, Georgia, that doesn't have it. But most states, they have an elective share. So even if for a spouse. So if you leave a spouse out and say, I'm giving everything to my children, or I give it to my siblings, the law is going to step in and say, well, you left your spouse out. It'll allow them to elect what they call against your will and take a piece. So you have to understand the mechanics of how the laws work. So even if you put something on writing, you also have to understand that someone can come along, especially talking about later marriages, and people might be upset if some spouse gets in there, but that's what the law provides. So we have to be mindful that the law is going to do certain things, and we have to work with that. Asset distribution, are you giving something to someone directly, or are you going to say, I don't necessarily think they're ready to get it right now, so I can create a trust that have something that have that property held for them. And that's not necessarily an insult, all right? Sometimes somebody might take it as, oh, why didn't you don't trust me to handle this properly? And maybe you don't, but also it's also potentially for safety reasons, for asset protection. It can help prevent if someone gets divorced later, if you have certain provisions in there, they can be protected. Or if they have government benefits that are in place, we have certain contingent language that says, if they're in a government benefit situation, create a trust, don't give it to them outright like I planned originally, hold it in this way to protect them. So don't necessarily think about it as they're going to be insulted. Many times you're going to protect them.
Right. All right. Now let's talk about the revocable living trust, which is the other benefit of having an estate plan in place. We already said if you have a will, you should also have, if you have a trust, you should also have a will in place. So make sure you have both in place so that you do not pass away intestate.
And this is also beneficiary choices, just like in a will, you can name them, but the will is worried about opting out of the intestate statute. When you do a trust, it's free form for you to do from scratch whatever you want. So you say, this is who I want. There's no presumption that someone's automatically included or not included. You just have to specifically lay out in a trust who will be the beneficiary. And also, if you don't, usually you have kind of default language to my heirs or something that will kind of follow a general statute, but you have to be very specific with trust, similarly to a will, who will get what, in the same kind of asset distribution. It's already in a trust, which is already being protected, but if you give it to them outright, many times they'll lose that asset protection. So you have to make that decision. do I keep it in this protected format, or do I make a decision that they are now ready to get it? But if you do that, like again, if they get a divorce, if they have a lawsuit or something like that, you expose that for asset protection purposes or government benefit purposes. So there are a lot of considerations in this, not only just the scale of the amount of funds, but really looking at the person's situation that you're giving it to. So whether it's 50,000 or 50 million, you have to examine what is the right situation to give someone money outright.
Right, and you also need to take into consideration the various laws of your state, because some states are considered community property states. And does that community property extend to the trust or not, if it is an individual trust? So all of those things have to be taken into consideration, which also leads me to the point that Keith mentioned earlier about don't try to do this yourself. You know, have a professional do it, and make sure it is somebody who is well versed in the planning aspect, in the trust aspect, in the tax aspect of all of it.
And I saw a comment of Robert put in there, Florida, 25% of all assets must go to the spouse. And that will vary by state. Like I said, Georgia, we don't have that. We have something called year support where they can kind of do a separate action, potentially get something. I'm a member of Georgia and North Carolina bars. North Carolina has a sliding scale. So if you're married a few short number of years, you might get 3% or 5%. All the way up to 15 years, you get 50%. So you have to know the rules of that state, and they also have an elective share statute that is what they call an expanded estate. So we're talking now about the will being part of probate and the revocable trust not being part of probate. But in certain states, the elective share includes the revocable trust, and includes, in North Carolina, insurance, includes all these other things, because they're trying to protect the spouse. So you have to know all the rules, because you're thinking, this is what I'm leaving, but you're really leaving, a larger piece, because the law is going to pull some things in. So it is very important to have that professional advice, particularly if you move states, because I don't know, especially we haven't really talked about this, but people might plan to move at some point, right? I'm in Georgia now, but in the future I might want to go someplace tropical, and then we go down to South Florida. Well, that's different laws. So if I write my plan in Georgia, or we talk in Georgia and have that family meeting when I'm in Georgia, I might need to have it again when I'm in Florida and re-examine.
Right. Yeah, I want to bring up a story, a case I had where it kind of combined all of these things, where my client and her spouse were in the middle of a divorce. Spouse had no will, but he had a trust. Spouse did a quick Google search and realized that she was his spouse, and his quick Google search told him that he didn't need to have a will because he had the trust. And then he wrote her a suicide note saying, I did a Google search. I know that you'll be okay because I have this trust in place and everything is in the trust. And her name was on nothing, like nothing. Everything he owned was in, or they owned was in his name. And then he committed suicide. So she was left in the middle of a divorce, which raises other issues for estate planning, right? With no will, which raised a whole other issues, and a revocable trust that was housing assets that she couldn't get to because they were all in his name. He hadn't properly funded the trust. Like everything was a mess. So, and they had minor children. And so he thought that she was going to be entitled to something just because she was the spouse. And, like we've said, no, you can disinherit your spouse in Georgia. You can't anywhere else, but the only way you can do that is to have it in place. So the revocable trust, the main part about the revocable is you can edit it, change it, move things, change how things are distributed. You can do all of that while you're living, right? A revocable trust becomes irrevocable upon your death because you are the only one who has the power to make those revocations.
Also irrevocable potentially upon your incapacity, because some of the documents say if usually make yourself the trustee first when you're setting up a revocable trust, and you'll have provisions that has say, if I'm found to be incompetent, and usually maybe it might be a physician statement or some people agreeing, they can remove you from that role. So if they remove you, now that many times that might be locked in, where they can't make any changes to it. So it could either incapacity also or death. So Shannon's right, just have these talks, because if something happens, and I do a lot of work with brain injury cases which happen at any point in time, someone has a stroke, someone has some kind of traumatic brain injury, it can happen at any point. So don't think you're gonna see it coming.
Right. And a trust kind of, I'm sure people have the misconception that you have to have, you have to be wealthy to have a trust in place. And that could not be further from the truth. Anyone that has a business owner, anyone that's a minor child, anyone that has real property should probably have the will and the trust. People that have more simple estates may not need a trust, but it could not be further from the truth that only trusts are only for the rich and famous.
And many times we'll go into this next session, beneficiary designations. These are the things that pass outside of probate, pass directly to life insurance. We put in here group policies and personal. Group meaning you have it many times through your job, you have an employer that offers that benefit where you can sign up as part of your group. That life insurance policy is just like any other. If you pass away, it'll pay out. It has a difference often that if you leave, your policy might not go with you. So that's also part of your planning, is you have to kind of know whether you're talking about a personal policy that is yours, that you can have with you for life, as long as you keep the premiums paid, which is another issue. All right, so that you have all those discussions, because you don't want a policy to lapse because people didn't know a policy existed and people didn't communicate. So 401ks, 403bs, while you're still employed, you're building those up. Maybe there's an employer match or something. But if you are separated, you leave that job, you have to take the funds out and put it into your IRA. What's the difference? The 401k or 403b, no, 403b is not ERISA, but a 401k is ERISA. ERISA says your spouse needs to be your primary. Sometimes they have certain rules. You might be able to wait a year or something like that, but it could affect your estate planning, especially if you do a later marriage. You're married, get divorced, now you put your children as your beneficiaries. Then you get a second marriage, that second spouse jumps in an ERISA plan to that first spot. So you have to be aware of that. They need to disclaim or something else. So you need to have these discussions, especially in blended families, about how things are working. And then pension plans, some of those pension plans end, depending on what you elect, the moment you die, those funds end. Some of them, you keep going to survivorship to your spouse or someone you name after you pass. You need to have those discussions in the family meeting so people understand that. If you have funds that you wanted a little bit more payment, but it stops at your death, the other people need to know that, because if they think there's money coming in, it's not, that's a nasty surprise. But all these together can be paid to someone directly, or if we talk about a trust, people think, well, I'm not wealthy. Well, you may fund a trust for a little bit amount while you're alive, but you have big amounts in these items that you might make the beneficiary of those, that life insurance or your 401k or IRA. You can use the trust as a receptacle for those. And now you can get large amounts that you can then manage, have the trustee manage after your death for those beneficiaries. So you kind of use these tools together.
Yeah, and along with the beneficiary designations, all of these things on here also have ownership. So if you are the owner of a policy and your named beneficiary has passed away, for instance, you as the owner, you need to go in and change that so that if something happens to you, you're the only one that can change that policy. And now there's going to be a mess. It's like a double probate, because there's going to have to be probate on top of probate for anyone to get that policy to pay out. So life changes. When you leave that employer and you no longer have that group policy, you may want to revisit your plan. All right, irrevocable trust. Essentially an irrevocable trust, like we already said, and since we're started running low on time, we're going to start wrapping this up. But an irrevocable trust gets its own EIN number. An irrevocable trust is for those long-term planning considerations for things that you don't need everyday access to, you don't want everyday access to, you're planning for long-term future things and you don't want to touch them. Because with an irrevocable trust, it's not easy, although you can make changes, but you have to jump through lots of hoops and it really is very difficult to do so. So people use these for things like special needs trusts, where there is somebody who is entitled to certain government benefits and you don't want them to have too many assets that would take away that entitlement. So you put it in a specialized trust for them. Or for instance, Medicaid planning purposes, where you have to have income below a certain threshold. Well, you shelter or house your assets in that irrevocable trust, and now you still own them because you own the trust. However, they're not countable for Medicaid purposes, and so you would still qualify for that government benefit.
So this is, I wanted to put this in here on purpose because a lot of times people need to think about having this in their documents, but they don't because it's not directly right in front of their face. They know if they had a sibling that had, say, autism and was on Medicaid, they would think about, okay, I need to make sure I take care of Johnny. Okay, but sometimes if I'm an uncle or childless uncle or aunt, and I just want to take care of a niece and nephew, I'm not thinking about their benefits. Or if I'm not married, I don't have any children, like Shannon said, if you, the thought is, if say you die intestate, if you go down and say there's no spouse, there's no children, they're gonna go up to the parent. Well, the parent at that point might be elderly, they may be on long-term care, they may be on Medicaid. So you have to start thinking at all the people that you could possibly affect. So your documents need to say, have some language in there that's contingent with many of these trusts to say, if any beneficiary that might be in a certain situation at the time, because you're doing this study in 2020, you hopefully won't pass until many years later. So at the time, you don't know where the other beneficiaries are in their lives and their health. So you need to kind of think about a lot of these topics and making sure these provisions are in your documents, both the trust and the will.
Right.
And then this is a same thing what we mentioned, the irrevocable trust, because you give it away, you have the ability to do some tax planning or some family planning where you can protect things for someone else. In a blended family situation particularly, I may be in a second marriage where I feel the obligation to take care of my spouse, but ultimately I always use the Brady Bunch. Say Mike Brady wants to take care of Carol Brady, but at the end of the day, he wants Greg, Peter, and Bobby to get his estate. Well, we have a certain trust called a Q-tip trust that will allow the spouse to get income for life, but ultimately the principal is going to go to wherever Mike directs it to go, which is probably going to be his children. So the law has certain trusts that you have to specifically plan for, and they have certain detailed rules, so we can't break all that down now. But if that is the case where you want to control the disposition, you might use a Q-tip. If you have a tax planning, we have a large exemption now, 11.58 million per person if you're very wealthy, and you might have the ability to do some tax planning. If you're some young Bill Gates, and you got your company stock and you're still in the garage phase, hey, put that 10 million of stock while it's still in startup phase in this trust. Use your exemption, and then later when it's 100 million, it's going to be passing outside of the estate. You did some tax planning. You gave it away when it was low value and removed it from your estate. You froze what we call an estate freeze. So there's some tax planning things in here. Of course, it won't be relevant to everyone, but just wanted to point it out because it might be relevant to a few, or if not now, at some point in the future. So.
Right, and that with that, know that Keith is talking about the federal exemption. Some states have state estate taxes where you pay a tax on the value of the estate at death, and some states have state inheritance tax where you pay taxes on anything that you inherit. So you have to know your state laws when it comes to what that looks like in various states. Georgia, we don't have either estate tax, estate tax, neither do we have state inheritance tax. But some have it, it can be 20% and upwards. So in planning all of this, you need to take that into consideration and have those discussions with your family so that they know. Added considerations that everyone should take into account when planning and when having these discussions. Real property comes with a deed. And some states allow you to transfer that property through a will, through a certain type of deed. Others do not. So know what the laws are and what that looks like so that you alleviate the possibility of setting somebody up to now have heir property. And heir property is property that the person whose name as ownership on the deed is deceased and nobody has done anything to transfer that ownership. So real property comes with the deed. Sometimes you have to talk about what's going to happen with that family home. Are we going to maintain it? Is somebody going to live in it? Are we going to pass it on? Are we going to sell it? So having that part of the discussion. And then also the part with regard to that same family home, are we going to turn it into an income producing property, make it rental property? And then you have to transition the discussion to, well, if so, what happens with the proceeds? So all of those things are excellent topics to bring into the discussion. Also, business ownership. If you own a business, have that discussion on what that looks like, how that business was set up in the first place can be critical to an estate plan. If you think you have a partnership set up, then that partner could potentially get the business. But if they think you have an LLC, then it's going to look like something else. So knowing how it's set up, what it looks like, and having a business succession planning be part of your estate plan. And we already talked about blended families. We talked throughout this about challenging individuals who could pop up and lay a claim to the estate. Sometimes they're predators, sometimes they're creditors, sometimes they're family, sometimes they're all the same. So having that discussion so that you know, if so-and-so pops up, this is what my intention is, and having that discussion with so-and-so as well. All right, let's see here. I believe we are at the end of our time here. I think we went over a little bit this evening. Anyone have any questions? I saw some as we were going in the chat. I think we answered them.
Yeah, I think we answered the ones in the chat or addressed them in some way.
Anyone have any questions?
Help families who may not have tangible assets.
Yeah, we talked about that.
And that's an important point that, we think about estate planning with property, but estate planning is also about people. So it's about, your family members and other things like that we talked about. Even if it's a small amount, if they're on a benefit that is means-based, and say Medicaid, you can't have more than $2,000 of countable assets. So it doesn't have to be a lot for you to have great value to do your estate planning on your end. And even if you're leaving someone $10,000, that can cause them a lot of heartache if you don't do it in the right way. So don't think it's just about scale. It's literally about what is the situation of that person that you are leaving it to. So it's about people.
Right, absolutely. So that you can set them up to be able to grieve without having to worry about the business of death and what all comes with that when you haven't set them up for success after death. So if anyone has any conversations or other questions, feel free to reach out to Keith or myself. Our information is there in the window. And this session has been recorded, so you will be able to have the benefit of reviewing any of the information. Again, my name's Shannon Wilson, and I'm with Legacy Legal here in Atlanta.
And I'm Keith Miles in the law office of Keith Miles in Atlanta and Gwinnett County in Duluth.
All right. Thank you all for joining us this evening, and you all have a happy holiday. Join us next month when we continue the discussions. Next month is January, and we are going to be talking about wills. So we started by talking about health directives, then we had powers of attorney, we had family meeting 1, family meeting 2, and in January, the third Tuesday of the month, third Tuesday of each month, we are going to talk about wills and the importance of of wills will give you a more specific look at what all is involved in wills.
And it just popped in my head, so forgive me. We listed the documents that you should talk about. We purposely did not mention power of attorneys because they end at death.
Right.
The process that we're talking about with going to court and doing the will, you're going to do a petition to get letters. And those letters are basically your after death power of attorney. So the court's going to say, okay, that person has passed, so any power of attorney they gave is no longer valid. So the court is not giving you a power of attorney and saying, here's the letters, either testamentary or if they didn't have a will, letters of administration, and that's your after death power of attorney.
Yep. All right, ladies and gentlemen. Well, thank you for joining us. And we look forward to helping you all create a legacy so that your families can grieve properly and comfortably without having to worry about the business.
Yes. And
Thank
happy
you.
holidays. Be
both.
safe. Happy New Year. Take care.
All right. Thanks, everyone.
Bye. Thank
Bye.
you.